My name is Camilla Zapata-Besso. I'm a barrister at Doughty Street Chambers and in the immigration team. I'm joined today by 4 barrister colleagues from the team. Next slide. As you can see from the screen, Marissa Cohen, who'll be dealing with recent developments in trafficking cases. David Lima, who will be updating us on Article 8 issues in default appeals. Michael Spencer, who will be looking at recent EUSS developments. And lastly, Phil Hayward, who will be dealing with recent case law on deprivation of citizenship. I'll be starting with an overview of the current and fast-changing immigration situation in the UK for Ukrainians. Now, we will try to leave some time for questions at the end of the webinar, but in order for panelists to be able to give considered answers to your questions and comments, I ask you to post them in the Q&A function at the bottom of the screen, so we can consider which questions we can answer in the time available at the end. I encourage you all to consider volunteering with Advice Ukraine. I want to thank Simon Cox of Doughty Street's immigration team, who is in the audience, and immigration colleagues from other chambers and firms for all their brilliant, heroic work on this so far. They've been working very hard and quickly to set up a voluntary initiative to provide help and advice to Ukrainians in solidarity. It launched yesterday, and they've already provided fact sheets which go into far more practical detail than I have had time to in this webinar. You can contact them to volunteer and to give pro bono legal advice. You must, of course, be qualified to provide immigration advice in the UK. So thank you for listening. Now I turn over to Marissa Cohen, who will be talking about trafficking developments.
Thank you, Camilla. Good afternoon, everyone, and thank you for joining us today. There's been a flurry of decisions recently in the field of trafficking, and I thought this would be a good opportunity to take stock as to where we are. Next slide, please. The 3 issues that I'm going to talk about are, firstly, decision-making in trafficking claims. Secondly, the interpretation of ECAT, otherwise known as the justiciability issue, in the context of applications for leave to remain. And thirdly, the admissibility of trafficking decisions and evidence in criminal appeals. Each of these issues, of course, deserves a seminar of its own, and I will try to summarize some of the recent case law. Next slide, please. The most recent case on our first issue, decision-making in trafficking claims, is TVN. But TVN should be read in light of the Court of Appeals decision in MN and IXU, where the court grappled with the relevance of credibility in trafficking decisions and the correct approach. Let's take a few seconds to read this extract from paragraph 127 in MN. The term credibility is used a good deal in the context both of asylum appeals and of decisions whether a person is a victim of trafficking. And we have detected a tendency to treat it as having some special technical meaning. But in truth, it connotes no more than whether the applicant's account is to be believed. In making that assessment, the decision maker will have to take into account all factors that may bear on that question. Likewise, the term plausibility is not a term of art. To say that a particular account or element in that account is implausible is simply to say that it seems to the decision maker to be inherently surprising, or the kind of thing that you would not normally expect to happen. And such an assessment will obviously feed into the overall assessment of credibility. So the weight to be given to it will depend on the degree of unlikelihood and how confident the decision maker can be about it. Perhaps both points are too obvious to need making, but if terms are used too regularly, they sometimes get in the way of the process of common sense decision making. As the court recognized here, credibility is often overstated, it is often over-relied upon by decision makers. None of this will be unfamiliar to those working in the asylum field, but this overemphasis can have a greater impact on claims brought by victims of trafficking and other vulnerable groups. It is worth remembering that in MN, the court was considering the competent authority guidance, which has now been replaced, as with other guidance, by the modern slavery statutory guidance for England and Wales and non-statutory guidance for Scotland. Next slide, please. The statutory guidance was considered in the case of TVN, where the court referred to the key elements to be drawn from the guidance at paragraph 34 of the judgment. I'm just going to highlight 3 points. Firstly, an assessment of credibility alone cannot of itself provide a complete answer to the question of whether the person is or is not a victim of trafficking. And that is, of course, reiterates what was held in Amman. And there is therefore welcome recognition here that credibility is just one part of the question or test to be addressed. And sometimes it's not even one part. I'll come on to that. Just going back slightly, there is a slight tension here between the way in which the deputy judge in TVN puts the question, i.e., whether or not a person is a victim of trafficking, and the test as it is put in the statutory guidance, which is whether on the balance of probabilities, there is sufficient information to decide if the individual is a victim of modern slavery. The ratio is the same, i.e., the same point is being made in that credibility is not the be-all and end-all of this process. But the way that the test is put in the statutory guidance may be considered to be more reflective of that reason. Secondly, in TVM, the deputy judge held that there is in fact no obligation to consider a person's credibility. This is another statement that sounds obvious, but which we do not see enough recognition of. It should not be surprising because a rational and fair decision maker should of course not start from the proposition that an individual may be lying. And thirdly, a causal connection is required between the alleged inconsistency or credibility issue on the one hand and the test to be applied or the decision to be made on the other. In other words, it is not sufficient that some kind of issue has arisen that causes a decision maker not to believe the applicant. There needs to be a relationship between that issue and the core of the person's account. So that is clearly some very welcome recognition on the proper approach to decision making in trafficking claims. Next slide, please. Our second issue is the interpretation of ECAT in relation to grants of leave to remain. You may recall the case of JP, which concerned what was referred to as the scheduling rule, which was the policy of the Home Secretary to delay consideration of discretionary leave until the outcome of the individual's asylum claim. While Mr. Justice Murray held that it was in principle permissible to postpone decisions in this way, the delays in practice, which was expensive, which also caused the loss of basic trafficking support, was not consistent with the UK's obligations under Articles 12 and 14 of ECAT. In the more recent case of EOG, Mr. Justice Mostyn held that it was unlawful to require those who were in receipt of a positive reasonable grounds petition to effectively be placed in the immigration hostile environment, pending a conclusive grounds decision. And the Home Secretary was therefore required to formulate a policy providing for the grant of discretionary leave, pending a conclusive grounds decision. And then in KTT, Mr. Justice Linden held that the decision maker was required to consider whether the fact that a victim had made asylum and protection claims, which were themselves based on the fear of re-trafficking, and they therefore needed to stay in the UK, were the basis to grant leave. Reading Article 14, Mr. Justice Linden held, in accordance with its ordinary meaning in its context, promoting the object and purpose of ECAT requires the grant of discretionary leave because avoiding the risk of re-trafficking, of course, fell within the purpose of ECAT itself. The underlying justiciability issue here is the Home Secretary's express policy of compliance with ECAT, as submitted and conceded in a long line of cases since the Tamiwan and including PK Gala, as accepted by the court. EOG and KTT have now been heard together by the Court of Appeal last month, primarily on the issue of justiciability of the Home Secretary's trafficking policy. Judgment is still awaited, clearly a very important issue since the SD line of case law and the lack of enforceability of unincorporated treaties. Next slide, please. In the meantime, we have the judicial review decision of the upper tribunal in SB to keep us going. In that decision, although the challenge to the decision to grant only 30 months discretionary leave on the facts of that case, and to the Home Secretary's policy on discretionary leave ultimately failed, the panel, which included the president of the upper tribunal, relied heavily on Mr. Justice Linden's judgment in KTT to enable it to assess the justiciability issue. Next slide, please. Our third and final issue is the relevance of trafficking decisions in criminal proceedings. The case of AAD at the bottom needs to be read in light of Bukani, Let's just remind ourselves of the particular context of the Bacani appeal, which was that the appellant appealed against a positive decision by the trial judge to exclude a conclusive grounds decision and expert trafficking report in his criminal trial. On appeal in Bacani, a distinction was made between expert evidence on whether an individual had been trafficked and conclusive grounds decisions themselves, which was said to be made by junior civil servants performing an administrative function, i.e. not expert evidence. This is worth recalling that in Bacani, the expert evidence in that case was rejected as not attracting weight because the expert had not demonstrated sufficient knowledge of modern slavery in respect of the particular facts at hand. And the expert had also not taken into account relevant considerations in reaching their conclusions. So that brings us to the case of AAD, where the Court of Appeal looked at the effect of Bacani when assessing the safety of a criminal conviction on appeal. Its ratio was therefore not concerned about the admissibility of evidence during the trial itself, although the court did make observations about it. What is important about AAD is that at the time of the trial, none of the appellants had been recognised as being potential victims of trafficking. And in that context, the court held that there was no doubt that a conclusive grounds decision could potentially be adduced on an application for leave or an appeal. The court also drew a distinction between the admissibility of conclusive grounds assessments of criminal trial and their relevance to information to which the CPS should have regard when deciding whether to bring a charge. That is clearly a developing area of law. But the court reiterated in overture terms this traditional approach to the admissibility of non-expert and expert evidence at trial and referred back to Bacani. Next slide, please. Oh, sorry, the next slide. So where did all this leave us then? Firstly, there has been really welcome progress in recognition of the correct approach towards credibility and decision-making in trafficking claims. Secondly, the very important justiciability issue remains live. I'm sure I'm not the first person to think this issue could continue to be thrashed out in the courts in time yet. And thirdly, conclusive grounds decisions are admissible in criminal appeals. The question of their admissibility in criminal trials remains a vexed one. Our anti-trafficking group in Chambers is due to hold a seminar in the next few months, so do look out for that. I shall hand over to my colleague now. Thank you for listening.
Hi, I hope you can hear me. I can't see my own face, but I'm presuming that you can. So this is my deportation update. So can we have the next slide, please? So in terms of key developments, it's clear that the most current issues in deportation over the last year or so and going on into this year will arise from the Court of Appeal judgments in HA Iraq, RA Iraq and AA Nigeria, which were all 2020 cases, but the vast bulk of Court of Appeal authority in 2021 constitutes a consideration and application of the principles set down in those cases. They are, however, in dispute. The Section State appealed all of the cases and they are due to be heard in the Supreme Court this May. So as a consequence, I was going to look a little bit more at the key themes, referring as I go along to more recent cases to understand what may or may not change in light of the Supreme Court's decision as it will obviously come after May. Right, next slide, please. So turning first of all to HA Iraq and RA Iraq. The key matters determined in those cases were: what does unduly harsh mean? What is the role of rehabilitation in the proportionality assessment? And how do the best interests of the children fit into all of it? And I'm going to look at each of them individually, but take them out of order. Next slide, please. So the first issue, best interests of children are integral to the proportionality assessment. Now, in HA and RA, arguments were made to the Court of Appeal that insufficient attention had been given to the Section 55 duty and to the propositions identified in Zumbas by Lord Carnwath when he was dealing with the issue of the definition of unduly harsh in KO Nigeria. The Court of Appeal in HA and RA rejected the argument that the court and indeed Lord Carnwath had not been alive to the best interest arguments, and it noted, the Court of Appeal noted, that at the outset of his judgment in KO, paragraph 15, he had noted that the statutory provisions of section 117C of the 2002 Act were intended to be consistent with the general interests relating to the best interests of children. Further, said the Court of Appeal, the need to consider the best interests of children that were involved was integral to the decision reached by the Supreme Court as to how to approach the unduly harsh test. So the court rejected the contention that Lord Carnwath had ignored the best interest of children in the approach that he adopted. But we'll go on to ultimately what the Court of Appeal concluded in a moment. But what is quite helpful is to have a look at Lord Justice Jackson's separate judgment, where he made 3 separate points in relation to the relevance of the best interest of the children. Firstly, he noted that the duty is on the decision maker to consider the matter from the position of the child, bearing in mind that the child will not be able to make their own view clear. Thus, of course, the decision maker and the tribunal should be alert to deficiencies in the evidential case being put forward, and arguably, I would suggest, proactive in what should be provided. Should the tribunal, therefore, if there aren't relevant reports available, seek to adjourn the matter to obtain those, because, of course, there is the obligation to look at the matter from the child's perspective. That's the first point. Second point, the obligation to consider the child means the focus must be on the individual rather than on the notional child. Thus, do not make generalized comparisons. Look at how the relevant factors impact on that individual. And it's that principle which was central, well, we'll see in a moment, to the conclusions the Court of Appeal reached in relation to the definition of how you approach unduly harsh. Third point, don't undermine the value of emotional harm and thus overvalue physical harm, bearing in mind their equal value as set out in section 31(9) of the Children's Act 1989, which defined ill treatment as including physical and emotional harm. Now, this has direct resonance in the consideration of the stay, as in child stays in the UK, as opposed to go scenario, namely the child goes with the deportee to whatever country they came from. It recognises that the tribunal may be more willing, or tribunals may be more willing to accept that there would be unduly harsh physical consequences arising from a child going with a deportee to live in a potentially dangerous physical conditions, but less willingness to accept the emotional harm arising from the stay scenario and therefore potentially lifelong separation from the individual who is being deported. And that theme was picked up upon by the Court of Appeal, and indeed relied upon by the Court of Appeal in the more recent case of MA Pakistan. Next slide, please. So what does unduly harsh mean? The court recognised that in KO, Lord Carnwath had referred to unduly harsh in specifically at paragraph 23, and it's this passage which will be the focus, I'm sure, of the Supreme Court's further determination on this matter in May. The bit in bold is key. Further, the word unduly implies an element of comparison. It assumes there is a due level of harshness, that it is a level which may be acceptable or justifiable in the relevant context. Unduly implies something going beyond that level. The relevant context is set by section 117C1, that is the public interest in deportation of foreign criminals. One is looking for a degree of harshness going beyond what would be necessary, what would necessarily be involved for any child faced with the deportation of a parent. Next slide, please. So it was accepted by the Court of Appeal that Lord Carnwath was requiring the unduly harsh requirement to set an elevated bar. But the Court of Appeal rejected the suggestion that he was attempting to define an acceptable level of harshness for a number of reasons. First of all, doing so, the Court of Appeal said, was conceptually problematic. For some children, separation will be harsh. For some children, as regards their relationship with the relevant parent, it might not be harsh at all. Attempting to find the normal level of harshness ran against the best interest of the child requirement to consider cases individually. We talked about that a moment ago in relation to Lord Justice Jackson's observations. Accepting that there was an ordinary degree of harshness gave rise to the risk that best interest considerations would be swept up by the general conclusion that emotional and psychological impacts of separation arising from deportation were ordinary. Fourthly, the idea that there would be an ordinary level of harshness gave rise to the risk that harshness experienced by a child would have to be of a rare level to meet the test. But the Court of Appeal said that's not correct. There was no reason why it couldn't be common for the unduly harsh test to be correct. And equally, fifthly, the Court of Appeal said there was a danger that tribunals would not accept that the test was met in commonly encountered patterns of cases, namely the factual scenarios that one normally sees in relation to children and the separation from their foreign national criminal parents. Again, said the Court of Appeal, this was not something which was justified. Next slide, please. So the conclusion that the Court of Appeal reached was that Parliament had intended for tribunals to make their own informed assessment in each case. There was no baseline of ordinariness as to the impact, and one must consider, the court must consider a whole wide range of factors when looking at the impact, including age, whether the child is living with the parent, and degree of financial and emotional dependence. And as long, said the Court of Appeal, as the tribunal considers the likely effect of deportation and decides, having considered those factors, that the effect would not just be harsh, but unduly harsh, there would be no error and the tribunal would be carrying out its task correctly. Next slide, please. So where's the role for rehabilitation? How much, so there was a question arose in all of the three cases, and indeed HA and RA, as to what weight should be afforded to rehabilitation when conducting the broader proportionality assessment. And the court was faced with contradictory authority. The Secretary of State argued that rehabilitation was irrelevant, referring to the fact that all rehabilitation would show is simply the person's return to the place in society where society expects them to be. And there is therefore no material weight to be given to rehabilitation in a proportionality balance. And that was an approach which had been adopted by the Court of Appeal in the case of Bin Buga. However, on the other hand, in the case of LG Columbia, the court had endorsed the finding of the first-tier tribunal that whilst rehabilitation did not carry great weight, it could still be a matter of some significance. Ultimately, the court concluded that rehabilitation should not be excluded from the proportionality exercise, and that it's a factor that should be considered when considering whether there are very compelling circumstances not to deport. That is because the prevention of reoffending is one of the elements supporting the public interest in deportation, together with the expression of public revulsion and the need to act as a deterrent. The weight to be given to deportation will depend on the individual case, but it will be rare for it to be given great weight. And further, it observed the court should be cautious about their own ability to make findings on rehabilitation and not rely on mere assertion. Next slide, please. Just on that final point in relation to HARA, one other issue that was raised was how the court should determine the seriousness of an offence. And it said that the court should determine, and tribunal should determine seriousness by reference to the length of sentence, not, for example, well, this person would have got this sentence, but they were given a third discount for a guilty plea. It would only rarely, said the court, be appropriate to consider discreetly aggravating and mitigating factors. And also, of course, one should avoid double counting of those matters as regards looking at the overall proportionality assessment. And that's a point which was picked up again by the upper tribunal in the case of Gordon. Next slide, please. Additional points were made in AA Nigeria. And I'll just go through these before just dealing with the final slide on what's going to happen in the Supreme Court or may happen. First of all, no need for the excessive citing of authority. And KO, Bin Los, NA Pakistan, HA, Iraq were enough. Secondly, assume the specialist tribunal knows its law unless the contrary appears in the judgment. That was the basis of the Court of Appeal's decision in the more recent case of KB Jamaica. There is no room for factual precedents. Attempts had been made in HA and RA to do so, and the court has deprecated that practice. Don't express decisions through categorizations of harshness. In AA Nigeria, the upper tribunal had referred to seriously harsh, which was very unhelpful, said the Court of Appeal. Rehabilitation should be taken into account, but it's not limited to the fact that no further offences have been committed. In SM Zimbabwe, subsequently, the Court of Appeal said that special attention should be given in circumstances where there's been rehabilitation with a victim. Equally, in Jallo 2021 Court of Appeal case, Court of Appeal accepted positive contributions to society arising from an offender working in the community to prevent others engaging in crime was also a relevant factor and a manifestation of rehabilitation. Final slide, please. So finally, where are we? We're in the Supreme Court. They have literally served the statement of facts facts and issues this afternoon. The Secretary of State's position is Court of Appeal is wrong to depart from what was said clearly by Lord Carnwath in KO. The proper interpretation of what he says is there is a normal level of harshness which should be identified and needs to be exceeded for the test to be met, and that there is contradictory authority on the relevance of rehabilitation which needs addressing. The appellant's position is the Court of Appeal correctly divined what was meant by Lord Carnwath in KO, but, and this is key, if that is not the case, KO is wrong and the Supreme Court is being asked to depart from KO. And finally, that the approach taken by HA, RA and AA, the Courts of Appeals, as regards rehabilitation is the correct approach. So watch this space.
Thank you, David. Change slides, please. So 2021 was the year that we saw the first year of the UK's exit from the European Union and the end of the transition period. It's also the year in which we saw the expiry of the deadline for applications under the EU settlement scheme on the 30th of June 2021. And it's a year in which we've seen some of the first legal challenges involving aspects of the scheme. So what I'm going to do in my 10 minutes is I'm going to look at a couple of those recent legal challenges and consider what we've learned about the EU settlement scheme from those cases. Next slide, please. Before I do that, quick look at some statistics. These are the most recent statistics from January 2022, and they bear out the complete culture change in decision-making at the Home Office in the EU SS team. We can see that there were 5.75 million people who have estimated to have applied under this scheme. And amongst those, there were 5.3 million grants. So the vast majority were granted, despite there being a much higher than expected rate of applications. Most of those were EU, EEA or Swiss nationals, but we can also see a significant minority of non-EEA nationals and around half and half, depending on whether they were granted pre-settled status or settled status. And perhaps this does show that where there's the will, there can be a real change in the way the Home Office makes decisions. We also see there's quite a significant number of late applications, which I'll be looking at shortly. Given the very high grant rate, the legal challenges have tended to focus on those at the margin of the scheme, particularly those who aren't workers or aren't exercising treaty rights and their eligibility for benefits, Zambrano carers, and extended family members. Next slide, please. So first thing we've learned from the scheme is that pre-settled status does not entitle you automatically to means-tested social security benefits. And that was confirmed by the Supreme Court in the case of Fratilla. That's a case involving a severely disabled man and his carer, both of whom were granted pre-settled status under the EUSS, but they were excluded in the income-related, the social security regulations from entitlement to universal credit because they did not have a right to reside. Specifically, those regulations exclude or exclude the right to reside where the leave to remain is granted on the basis of a limited leave to remain under the Appendix EU. Court of Appeal said that's discriminatory under Article 18 of the Treaty on the TFEU, and therefore the rules would need to be changed. But actually, then there was a reference from the Northern Irish Court, which went to the Court of Justice, and the Court of Justice held there's no breach, there's no discrimination under Article 18 TFEU, and that's because an EU citizen can only claim equal treatment in respect of social assistance if his residence complies with the conditions of the directive. So the mere fact that you have leave to remain is not enough to entitlement to social assistance or even to the protection of Article 18. You also have to be complying with the conditions of the directive. That means you need to be a worker or have retained worker status or a family member. And the Supreme Court confirmed that, rubber stamped that approach from the Court of Justice. Interestingly, declined to consider an alternative argument, which was raised only on appeal to the Supreme Court, as to whether that prohibition could lead to a breach of the EU Charter of Fundamental Rights, specifically Article 1 on the right to dignity, Article 7 on the right to family life, and Article 24(2 on the rights of the child. So there may well be some area for challenge at the margins around that issue. Next slide. Second thing we learn is that the Secretary of State got the law wrong when she wrote the rules in relation to Zambrano carers. And this is the case of Akinsanya. The Court of Appeal judgment was handed down early this year. And that case concerned, well, just to take a step back, the first point to note about Zambrano carers is they're not covered by the withdrawal agreement. So there was no requirement under EU law or under the terms of the withdrawal agreement for the Secretary of State to include Zambrano carers within the Appendix EU. But nonetheless, she did do so. But then having done so, she adopted a very restrictive definition of a person with a Zambrano right to reside, excluding anyone who already has leave to remain on another basis, for example, under Appendix FM. In guidance, she went further and said that you can't even have, the Zambrano right to reside doesn't even arise if you could apply for Appendix FM leave, but fail to do so. The Court of Appeal considered two issues. First, what's the content of the Zambrano right to reside under EU law? And under EU law, it endorsed the Secretary of State's approach, saying that Zambrano is effectively always waiting in the wings, and the Zambrano right to reside only arises if you lose any domestic law right to reside, for example, any Appendix FM leave. In other words, when your Appendix FM leave expires. But under the EEA regulations, the Secretary of State had interpreted the UK national law wrongly, because Regulation 16 as drafted was much broader than the EU law position required. And it was drafted in terms that were simply too clear to be read down in any other way. The result of all of that is the Secretary of State's going to have to go away and reconsider, or has agreed to go away and reconsider Appendix EU in relation to Zambrano carers and promulgate a new policy before the 25th of April 2022. So watch this space. And Simon Cox and I, together with Bayer Rivers from Hackney Law Centre, will be doing a seminar on Thursday, talking in a bit more detail about the Akinsanya case. Next slide. One of the concerns that we had in Akinsanya was in relation to multiple applications, because paragraph 34BB of the immigration rules says that if you make a subsequent application, that's treated as a variation of the previous one, essentially a withdrawal of your earlier application. And the concern was that people might have outstanding Appendix FM applications and then want to make an application under Appendix EU, hedging their bets on the outcome of the Secretary of State's review of the rules in relation to Appendix EU and be precluded from doing so. So in the consent order, there was quite a detailed consent order attached to the High Court judgment in Akinsanya. It was agreed that paragraph 34BB would be disregarded in those circumstances. And that's also being carried through more generally in that EU SS guidance is now saying that both applications, the Appendix FM and the Appendix EU applications, should be considered. And if they both need to be granted, then the senior caseworker will need to be consulted. And there was a recent letter to ILPA in which the Home Office officials confirmed that they are reviewing the policy on handling multiple applications. Next slide, please. Another concern we had in Akinsanya was obviously about late applicants, particularly because many people, Zambrano carers, would have held out from applying before the expiry of the deadline because they're not sure what the rules are going to be, and they're still in that position now. They don't have any specific protection or extended protection under the citizens' rights regulations, but they are potentially protected under the withdrawal agreement. So in the consent order, there was an agreement that those who make late applications will have an entitlement to work, study and rent a place to live pending final determination. And this has also now been confirmed more generally in a statement from the Home Office in that, as I understand, is now the Home Office practice in issuing certificates of application where applications are received after the deadline. That doesn't necessarily mean that the EU SS application will be granted, and there will still be a question about whether there was good reason for the late application. But while if people are waiting for their applications to be determined, they will have the right to work, study and rent a place to live. Next slide, please. Final area to explore is in relation to, or has been potentially explored in legal challenges in relation to extended family members. They can't apply for a permit if they're outside of the UK under the EUSS family permit scheme within Appendix EU. Only family members or durable partners, as strictly defined, can do so. And that created quite a difficult anomaly for those who might have applied by the deadline of 31st of December, because they, under the family permit deadlines, they needed to apply by the 31st of December and then arrive. The permit is only valid until the 30th of June. But many extended family members didn't receive their permit before the 30th of June, or are still waiting for applications to be determined or determined on appeal. And the Home Office position was tough luck. If you don't come here by the 30th of June, you can't, the permit is invalid. That was challenged by judicial review, and there's now been a concession, particularly looking at those who couldn't travel to the UK by the 30th of June deadline under their family permit because of compelling compassionate reasons in relation to ill health or in relation to COVID-19. And those are interim concessions that are going to be in place until the rules under Appendix EU can be amended. So looking at all of that together, we can see that most of the legal challenges have been around the margins of the scheme, but there's still quite a lot that we don't know about, particularly for Zambrano carers, where we're waiting for a review of the rules before the end of April, and for extended family members, where we're also waiting for changes to the immigration rules. Thank you.
Hi there. I've got the final segment in this afternoon's presentation, and I would like briefly just to address some of the developments in the case law on deprivation. And it's really with reference to two cases, firstly Begum, and then secondly a recent decision by the tribunal, a case called Ciceri, where Begum and other case law is simply applied just to sort of consolidate the tribunal's existing case law on deprivation. Can we move to the next slide, please? Now, just to begin with, if I can just remind you of the sort of the basic powers that the Secretary of State has to deprive people who've acquired British citizenship. It's a discretionary power. The general discretion is set out in section 42 of the British Nationality Act. So it enables the Secretary of State to deprive a person of citizenship if satisfied. So the person to be satisfied is the Secretary of State that the deprivation is conducive to the public good. Then there is a more limited power, but it's a power to be exercised in certain circumstances in relation to people who have registered or naturalized, and where the Secretary of State is satisfied that naturalization has been obtained by means of fraud, false representation, etc. So those are the basic powers. The overarching and wide power, the discretion contained in 42, and then a subsidiary power in 43. Next slide, please. Now, some of the other important provisions, just to remind you of, under 44, the Secretary of State cannot exercise his powers if the result would be that the person would be left stateless. And that is then subject to a qualification by the further power introduced in section 44A when the legislation was amended. And again, these really focus on the view of the Secretary of State that the person would be made stateless, or that it's appropriate to take away citizenship, notwithstanding that, because of the conditions in 4A. Now, the last section I've got obviously is one which is controversial given the provisions in the new bill that under legislation as it stands, that the Secretary of State must give written notice of the intention, the reasons for it, and that the person has a right of appeal to challenge the decision. Can we move to the next slide, please? Now, so far as the right of appeal is concerned, now this perhaps is a source of some of the current or some of the past difficulties in the legislation, because the actual right of appeal says really very little about the content or the basis of the appeal. It simply allows the person to appeal to the first tier tribunal against the decision, except where the case would go to SIAC because of the reliance on information that cannot be made public. But really, quite a lot of the difficulties in the law, I think, and understanding what the ambit of the appeal was, have arisen really from that rather vague statement in the primary legislation. Can we move to the next slide, please? So Begum then gave judgment allowing the Secretary of State's appeals against a positive and sympathetic approach in the Court of Appeal. One of the first issues that it really sort of knocks finally on the head, I mean, there is other case law from the Court of Appeal which deals with this, but what it really finally deals with is the divisions in the tribunal between these two cases, Deliaci and Perzada, when there were different views about the role of the tribunal and actually looking at the discretion as originally exercised by the Secretary of State. Mr. Justice Lane had taken the view that the ambit of the appeal was wide, and the tribunal actually had a wide power of review in exercising its appellate jurisdiction, and that it could look at the decision and the basis of the discretion afresh to decide whether the discretion had been correctly exercised. Mr. Opperton in Perzada took a very different view. And if I move on to the next slide, that's clear which side of the line the Supreme Court came down on, and it's rejected the Deliaci type approach on the basis that the person with the discretion is the Secretary of State, looking back literally at the wording of Section 40, and that the legislation and the structural legislation simply doesn't contemplate any wider role than really effectively review. Can we move on to the next slide, please? I think what perhaps is helpful, Begum is generally, it might be fairly said, a not entirely helpful judgment from our point of view. But there are perhaps sections of it which are useful in that there is quite a lot of detail in terms of relevant principles to be applied. And the content really of the appropriate decision making on the part of the Secretary of State. Can we move to the next slide, please? In the time available, I'm not going to address those in massive detail, but just perhaps move on to the second section, at paragraph 71 of the court's judgment, which is something that is returned to in Ciceri. The tribunal referred very explicitly back to the guidance given in terms of overall approach in deprivation cases. So it sets out a number of general principles, and again reiterating the importance of the content of the decision making in terms of considering the actual decision to deprive citizenship on the basis of the Secretary of State's exercise of discretion. It is a process of overall review, where a separate question in relation to human rights arises, then the tribunal or the court should form its own view. Can we move on to the next slide, please? The second key decision, Ciceri, really is a sort of consolidation of earlier tribunal case law and draws on a number of the important decisions, not only Begum, but cases such as KV Sri Lanka, and Aziz from the Court of Appeal, which perhaps slightly strangely don't seem to be, well, they're not referred to by the Supreme Court in their judgment, despite their relevance. The last in this list is perhaps a sort of more useful and helpful judgment, this case of Lachi, which I think is specifically helpful on the issue of delay, where the Secretary of State has delayed over some period, and on a factually nuanced basis, it becomes unreasonable to uphold the deprivation when the balancing exercise under Article 8 is conducted. Can we move to the next slide? Now, just to take an overall view of the guidance that Ciceri provides, it applies Begum into the in the context of deprivation appeals being heard in the tribunal. So really the same principles apply whether an appeal was going to SIAC or, as in the normal course of events, to the tribunal. And this summary really is taken from the fairly helpful headnote to the case. So the first question is just to establish whether the condition precedent for deprivation, as it's normally likely to exist in these cases, exists. But perhaps helpfully, and it's why perhaps I place some emphasis on the fairly detailed guidance provided by the Supreme Court of Begum. It does refer, the tribunal does refer back to the principles as they are set out in detail by the Supreme Court at paragraph 71 of the judgment to which I've just referred. Then the next question becomes whether if there is ground for deprivation established, whether it will be compliant with human rights. The balancing exercise has to be conducted on the basis of the effect of deprivation. So it will be forward-looking. The tribunal, and really reiterating other decisions by the Court of Appeal, emphasises that it's not a proleptic approach looking at the consequences of removal, because clearly if deprivation is upheld by the tribunal, then the next step in the process would normally be deportation, at which point it would be possible to consider the consequences of being removed from the UK, and clearly the general view is that that's the appropriate stage to take a more proleptic and forward-looking approach. But it doesn't mean that it's entirely irrelevant, as really confirmed by the Court of Appeal in cases such as Aziz. If, for example, there would be a very strong case to resist deportation, or there's evidence that being left on that because of the legal difficulties in deporting someone in a sort of fairly protracted limbo, which might perhaps have an impact on other members of a family unit, then it might well be relevant for the tribunal to look at the effects of deprivation at that point. But in the generality of cases, it probably won't be particularly relevant. Can we move on to the next slide, please? Now, just to say one or two things about delay. Delay was certainly something that has figured large in quite a lot of the appeals involving deprivation, because there have been some instances of extraordinarily long delay between an initial notification by the Secretary of State of an intention to deprive someone of their citizenship and the eventual taking of the citizenship. In a lot of cases, the simple effect of delay has not been sufficient. There are a lot of cases which were brought in the light of the Home Office was acting on the basis that a grant of citizenship which had been obtained fraudulently was simply a nullity, and that it might not be necessary to do anything further. That, as the Supreme Court confirmed, was an erroneous interpretation. Nevertheless, delay didn't have significant weight in that type of case. But I think perhaps more positively, there is this recent judgment from the Court of Appeal in this case of Lachi, where in upholding a determination by a first-tier tribunal, it found that the tribunal had been entitled to conclude that delay did actually tilt the balance in favour of the particular individual. But what it does really emphasise is that if delay is going to be made out as a significant factor, one that will really tilt the balance, that firstly, it's going to have to be a significant delay. And in the case of Laci, it was extraordinary because there was a 9-year period between initial notification and eventual action. And then it has to be an argument about the impact of delay, which is put in a sort of nuanced and very factually related way. In this case, there was a very long delay. And there were things that happened during that delay, such as the fact that Mr. Laci applied for a passport and was reissued the passport, which was not entirely obviously consistent with an intention to deprive him of his citizenship. The Secretary of State had made, he'd invited Mr. Laci to make representations against the decision to deprive him of citizenship, and then actually did nothing about the representations that he made. The court also thought that there was a period of uncertainty between deprivation and deportation. The Secretary of State argued that that would simply be a short period, but on the basis of what they clearly thought would have been a strong case against deportation had the deprivation proceeded. He'd had settled employment over a very long period, and there were very glowing references from his employer about his work. And it was the fact, even relatively short in terms of a possible period of limbo, that he would lose his employment. And in the face of such sort of glowing references, that really he would lose that particular job. So on the particular facts, the delay was actually found to tilt the balance in his favour. So that perhaps is really the most positive recent decision in the face of other rather unhelpful judgments. Perhaps the other thing I would just simply refer back to is what is said at paragraph 71 in Begum, because I think that perhaps there's quite a lot that can be unpicked from that potentially is of use in terms of unpicking Home Office decisions in these cases. Thanks very much.
I can see we don't have any more questions. So I'm going to finish off by saying that last year has been a busy one, like most years, for immigration and asylum. We have tried our best to address some of the key developments as broadly as possible. So hopefully there's been something in here of direct interest to all of you. I remind you that all the panelists are contactable via the immigration clerks at Doughty Street Chambers. That brings us to the end of our seminar. Thank you all for attending.